Good morning, good afternoon, or good evening, depending on where you are joining us from. My name is Alejandro Castro, and I am managing partner at Union Andean Intellectual Property Solutions. And it is my pleasure to welcome you to today's webinar, Navigating Brand Protection in the Andean Community and China. We're honored to have with us Ricky Tan, Trademark Director at Jiaquan IP Law in China, who brings extensive experience managing complex trademark portfolios across multiple industries and regions. Together, Rick and I will guide you through the current landscape of trademark protection in the Andean community with a special focus in Peru and China. Our goal today is to provide you with a comprehensive and practical understanding of the trademark system, registration process, as well as the key challenges and enforcement strategies involved in safeguarding your brand in these important markets. I would like to highlight that a key reason for Union Andina to decide to partner with Jiaquan IP Law for this webinar is a recent opening of the megaport of Chancay, which is located about 75 kilometers north of Lima, Peru, and it was inaugurated in November 2024. It is one of the largest infrastructure projects in Latin America developed with Chinese investment and leadership, which is part of China's Belt and Road Initiative. And this modern port in South America is the first intelligent and automated facility, and it's set to become the leading logistics and trade hub for the Pacific South American region, greatly improving Peru's connections to global markets and strengthening trade ties with China and the wider Asian region. In this session, we will cover 4 topics. In the first topic, we're going to talk about the step-by-step trademark registration procedure in Peru, in the Andean community and China. We're going to talk about the trademark legislations in each of the countries, and in particular, we're going to talk about the Andean community and how the common regimen on trademark legislation works in this region. In the second section, we're going to talk about administrative disputes, which includes opposition, cancellation actions, and other administrative matters in that sense. The third part of the webinar, we're going to talk about effective brand enforcement strategies to prevent infringements. And in the last section of the webinar, we're going to talk about the implications of unfair competition laws on trademark protection. Our agenda is designed to equip you with actionable insights that you can apply immediately to strengthen your brand's position internationally. We look forward to an interactive and insightful session. Thank you for joining us today. Well, I'm going to start with the first topic on this webinar. It's about the trademark registration and legislation in the Andean community. I'd like to tell you about the Andean community. So let's talk about the Andean community. The Andean community is an international organization whose main objective is to achieve the Andean integration. As you may know, the European Union is part of our European integration. And in Europe, they are, let's say, in the later stages of their own integration process, as they have a common currency. Here in the Andean region, let's say that we are in a middle stage. And as part of this integration process, we have some important milestones as part of our integration history. And one of these milestones is a regulation of some important aspects of the Andean legislation. And one of these aspects is, of course, the intellectual property. So we have what we call decisions that actually are binding for the Andean community countries. As you can see in the slide, we're talking about Colombia, Ecuador, Peru, and Bolivia, which are the Andean countries. And these decisions, which are legal instruments for the Andean community legislation, regulate different topics. You can see on the screen that actually we have 5 decisions that regulate IP, copyrights, plant varieties, access to genetic resources, and treatment of foreign capital on trademarks, patents, licenses, and royalties. But for this session, we're going to talk about Decision 486, which is a common regime on industrial property, which is in force since 2000. But before starting to talk to you about the details of how the trademark registration process actually works for the quick facts for you to know how to handle trademark applications in the Andean countries. One aspect that you should know is that we have what we call a registration principle. So in order for you to have a trademark or trademark rights in the Andean community countries, you need first to register your trademark. So in order to have enforcement rights, or even if you have a company with a trademark, if you want to engage in some business or commercial activities, you would need, first of all, to have your trademark already registered. If you don't have your trademark registered in Peru, Colombia, Ecuador, and Bolivia, you won't have any IP rights in that sense. So it is important, of course, to have it registered. A second aspect that you should have in mind regarding the Andean countries is that we do not have a community trademark. As you know, the European Union, they have a community trademark, which actually is with one trademark application, which is called the European Community Trademark. After you have passed throughout all the trademark registration procedure in the European Union, you will have a community trademark, and of course, enforced in all of the European countries. We don't have that, so if you want to have protection in the Andean region, you need to file an individual trademark application in Peru, Colombia, Ecuador, and Bolivia. A third aspect for that, but Colombia is the only Andean country which is part of the Madrid Protocol. So let's talk about some details. Of course, if you want to have your trademark protected in the Andean country, you will need to file a trademark application with a respective administrative authority, and each Andean country has its own trademark office in that sense. Regarding the power of attorney for Peru and Bolivia, we just need a simple copy of your POA or your power of attorney. We don't need it legalized, and we don't need a hard copy. But from the case of Ecuador and Bolivia, you need to have your power of attorney legalized up to apostille. Regarding the length of the procedure, in Peru it's around 3 or 4 months, Colombia 8 months, and Ecuador and Bolivia it's around 1 year. Other important aspect is that in all the Andean countries, we have 2 administrative instances. So if your trademark gets rejected in the first administrative instance, you have the right to appeal. And of course, the Chamber of IP will actually review the case. Peru and Colombia, we have multi-class registration. But in the case of Ecuador and Bolivia, you want to protect your trademark in different classes, you would need to file an individual application for each class. And fast track, Colombia has a pre-approved products and services list. We don't have that, not even Peru or Bolivia, but just Colombia. So let's talk about the trademark registration procedure. This is the general structure of the trademark registration procedure for the Andean countries, as it is set forth in Decision 486 of the Andean Community Legislation. So of course, everything starts with filing the trademark application. And in order for you to have a filing date, so your trademark application can be admitted for processing, the first minimum requirement is to identify the applicant. Then, of course, attach the trademark specimen if you have one, a description of goods and services, and finally, pay the official fees. Those are the minimum requirements in the Andean countries in order to have a filing date. Of course, if you don't have a power of attorney, in case, of course, for example, you're hiring a lawyer or a law firm or any representative in each of the countries, you would actually need to submit it within a time frame of 60 business days after you receive the official notice from the trademark office. Then if you are claiming priority, you have 9 months in order to file the priority document. I'm not talking about claiming priority per se, which is 6 months, as you know, but I'm talking about filing the priority document. So you would need to file a certified copy of the priority document within a time frame of 9 months, but not counting from the trademark filing date of the Andean community country in which you have chosen, but for the original trademark application in which actually you're claiming priority. After that, once we have concluded successfully the formal examination, the trademark is published in the official gazette. There is a 30 business day time frame or period in order for third parties to file on a position or challenge your trademark application. And then, of course, we have the last stage, which is a substantive examination. In this examination, the examiner will analyze your trademark application based on 2 grounds. The first one is the absolute grounds. The examiner will actually check if your trademark is perhaps descriptive or generic, and in that sense, of course, it would be an absolute prohibition, or if your trademark has any trademark collision or is colliding with other IP rights. For example, in that sense, the examiner will do a research or a search in the corresponding class and see if there are any similar trademark, which means phonetic or figurative aspects, as well as if it has any commercial connection with your product or services. And based on that, finally, the examiner will decide if he's going to grant your trademark or reject your trademark. If the examiner rejects your trademark, you will have the right to appeal. But if it grants your trademark with a decision, it would finally issue a digital certificate in the case of Peru, Colombia, and Ecuador. So let's talk about the types of trademarks. So I'm going to talk to you about non-traditional trademarks, which is a really, let's say, important topic in that sense. But first, let's talk about what is a trademark. So according to our Andean legislation, the first requirement for a sign, let's say, to be actually or to constitute a trademark is to distinguish a product or service in the market. It has to be this capacity to distinguish a product and service. And the second one is that the trademark has to be susceptible to graphic representation. And regarding this second requirement is basically for third parties to enforce their right. So third parties need to know what if a trademark is going to be registered in the trademark system, and of course they need to have a graphic representation in order for them to enforce their rights. So that's of course that's common sense for third parties to enforce their rights. And a second aspect, and from this part, I'm going to start to talk to you about non-traditional trademarks. Of course, we have an open list of what may constitute trademarks. As you can see in the screen, words, combination of words, image, figures, symbols, portraits, sounds, and scents, which is, of course, something interesting for you to know. So in theory, we can actually, in any Andean community contract, you can actually register a scent. But of course, at this point, there's no trademark office within the Andean region that has registered a scent because there are some challenges for the trademark office to actually grant a trademark registration over a scent, which is basically regarding the second requirement, which is graphic representation. So it's a challenge to have a graphic representation for a scent, which is the main reason why we don't have uh, so far a scent trademark granted in the Andean region. And of course, we can register colors as well. And well, Peru is part of the Singapore Treaty on the law of trademarks. Actually, Peru is the only Andean country which is part of the Singapore Treaty. In the Singapore Treaty, the treaty actually listed these non-traditional trademarks in Rule 3, as you can see on the screen: three-dimensional marks, hologram marks, motion and position marks. But also, as you just saw previously, Decision 486 of the Andean legislation actually has an open list of what may constitute trademarks. So, for example, Colombia, which is not part of the Andean of the Singapore Treaty, they have already registered the red sole of Louboutin, for example. As you can see in the screen, it was granted in Peru in 2022 and then in Colombia in 2023 for class 25. So, which means that actually our Andean trademark legislation allows even for these non-traditional trademarks to be protected in the region. So, of course, we also have tactile trademarks. As you can see on the screen, we have the Ragol part trademark. So actually the surface texture is protected, and it is protected in Colombia and Ecuador. So the applicant, for this case, needed to actually give a detailed description of the trademark as part of the trademark application, and even that the applicant actually submitted a special texture paper in order for the examiner to know that actually that was the texture that they were looking for to protect. We also have sound trademarks. For example, in Peru, of course, you know that a sound can be represented or can be graphically represented on a musical staff, and in that sense, the sound of this trademark, which is really well known in Peru, was registered. This was registered many years ago already. I don't know, I'm gonna play this video so you can hear what is the sound. So that sound, of course, can be reproduced on the musical staff. And I want to talk to you about color trademarks, which is really interesting. I just took this example from Colombia. Actually, this color or this soft drink, which is called Postobon in Colombia, the pink color of this soft drink is really well known in Colombia. Of course, the owner of the soft drink wanted to protect actually the color. And in the Andean legislation, you have two routes. The first one, to protect the color as long as it is protected with a specific shape. But this shape doesn't have to be per se distinctive, but the whole combination, color plus shape, has to be distinctive to qualify as a trademark. So that's the first assumption, or the first type of protection you have regarding colors, which is, again, the combination of color plus shape, but the shape per se doesn't have to be distinctive on itself. And in the second one, you have an isolated color, which is actually part of some prohibitions that we have on our Andean legislation. But if you can actually prove to the trademark office that this isolated color has acquired secondary meaning through extensive and exclusive use, of course, you can have a granted trademark right regarding this isolated color. For the Postobon case, actually, they didn't claim to have an isolated color, but they filed actually the combination of a color plus shape. And a second aspect on this case, which is also interesting, is that the color pink Pantone was distinctive for Manzana Apostol, for the soft drink, since it is not descriptive, generic, nor commonly used for apple flavored soft drinks. So that's also important for you to know. And well, this is the first part of my presentation. As you can see, it is really important for you to know how actually the trademarks system works in the Andean community, that we have a common regimen on trademark protection for this part of the region. And now Rick is going to talk about how actually the trademark legislation works in China. Well, thank you for stay tuned for this first part of the presentation. And now, please, Rick, go ahead. Thank you.